Welcome to Sakshi TV special immigration show with attorney Mr. Chand Parvathaneni from Managing Attorney Law of Sim Parvathaneni and Brown. Please note that Sakshi TV now has 3 immigration shows every week on Thursdays at 5 p.m. EST with attorney Mr. Parvathaneni, Wednesdays at 5:30 p.m. EST with attorney Prashanti Reddy in English, and on Friday at 6 p.m. EST with Banu and Lindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on this show is not legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, you can contact the attorney directly. Mr. Chan needs no introduction, but if you need any consultation, please log on to spblawfirm.com site for contact information. When you connect with them, don't forget to mention Sakshi TV. From the beginning, spblawfirm.com site has put a wealth of free information and online tools in the hands of the immigrant community and for the benefit of US employers. The www.spblawfirm.com site provides you with the latest cutting-edge information on US immigration laws and policies explained in terms you do not have to be a lawyer to understand. We will continue the knowledge session along with the news and updates on the latest immigration, followed by a Q&A. Before we get into the topic, you can call us on the numbers on the screen, questions related to immigration, and also ask for tips. So for today's topic, we have H-1B layoffs, new H-1B filings, and H-1B lottery issues. So without any further delay, let's welcome Mr. Parvathaneni on our show. Hello, Mr. Parvathaneni. I hope you're doing well.
Hello, Shivani. Really good. And thank you all Sakshi TV viewers all over the world for joining in today.
Thank you so much, Mr. Parvathaneni, for tuning in. So Parvathaneni Garu, today let's talk a little about the latest immigration updates this week. Do we have anything or do you want me to get onto the topic?
Sure. In terms of news, currently there is a proposal out there, and it's a proposal by USCIS where they're actively trying to increase the fees, all the filing fees this year. And right now it's under a public comment period. And this week, the public comment period has been extended until March 13th. And what that means is everybody should contact USCIS. They should go to the regulations.gov website, put in the docket number, and submit their comments, because the fee increase for a lot of filings, it's a big increase, it's a huge increase, and USCIS listens to the comments. So it's a good idea for everybody that is getting impacted, anybody that's dealing with the immigration aspects. It's a good idea. Go to the regulations.gov website, put in the docket number for the proposed rule that talks about the fee increase, and put their comments in. So that's very important. And then in terms of news, the priority dates. So the visa bulletin for March has come out. The visa bulletin is not very promising. The dates have not moved forward. And even in terms of the forecast, it doesn't look like the dates for EB2 or EB3, it doesn't look like they're going to advance any further. At least not too drastic movement. And what that means is more than likely people are stuck at 2012. 2012 is where EB3 is currently stuck at, and 2011 is where EB2 is stuck at. Hopefully, we want to see some positive news in the next couple of months, but this month's bulletin was not a great bulletin.
Okay. So, Mr. Chan, let's continue with the topic today. So my first question to you is, a lot of job layoffs are happening, and what happens when someone on H-1B is in India for, let's say, a vacation and finds out they are laid off? So can they travel back to the US?
So if somebody is in US and they get laid off, they luckily have 60 days to find a new job. And within 60 days, more than likely, people are finding new jobs. The problem, however, is what if somebody is in India? They have left for India for a vacation, a small vacation, and realize that they have lost their job. What happens during that time? During this time, the 60-day rule does not apply. So when somebody is in India and unfortunately, say they find out that they lost their job, there is no 60-day rule per se. So what are the options? So the first question during that time is the H-1B visa even valid? So if somebody has their passports stamped with the H-1B visa, if the visa is active, technically the H-1B visa is still active. Now the next question is, can they travel to USA on that H-1B visa? Since the visa is active, but they lost their job. So can they utilize the 60-day time period and come back to US from their vacation? So unfortunately, so what happens is the H-1B visa is active, but on the day they come back to US, they have to impress the CBP officer on what they will do in the country, and they're required to have a valid and an active assignment. So they need to have a job. So the bottom line is, if they don't have a job, even if they travel to US, even if the airlines did not say anything because the visa is active, at the port of entry, CBP could cause an issue. So in general, what they're supposed to do is, if their visa is active, talk to the employer and see if they just got a layoff notice or if they have been actually been terminated. If they received a termination notice and the job is terminated. If the job is not terminated, talk to the employer and see if their employment is still active until the final date of termination. Because sometimes it's common for the employer to say, hey, we're giving you a heads up. We will terminate you in about a month, for example. So if the job is not terminated yet, get back into the country while the job is still active. And the other scenario, the employer has notified them that no, they have been terminated and the job is gone. So during those cases, they cannot really go back to US because they don't really have a job. But unfortunately, they have to stay back and find a new job. And that is the only way they can go back into the country. Once they get a new H-1B visa approved by the new employer, they can go back. The only good thing is, since their visa is active, at least they don't have to go for visa stamping again.
Yes. So, Mr. Parvathaneni, can someone who is laid off while on H-1B convert their spouse's dependent status if their spouse is in H-1B?
Sure. So another common scenario that we see is both the husband and wife, both of them are on H-1B, and say one of the spouses, while they're traveling, say they're out of the country, one of the spouses finds that they lost their H-1B job. And how does the other spouse come back without a job? So one of the options is the spouse who lost the job on H-1B status, they can convert back to their spouse's dependent status. So they can apply for H-4 visa, and they're eligible for a H-4 visa, and they can enter United States on H-4 visa. So that is completely legal, and that's an option. So that's a good option where somebody whose spouse is also on H-1B, now they have a backup option where they're able to apply, go to the consulate, get H-4, and come back on H-4 visa. This is also valid if the spouse is on another work visa. Say, for example, the other spouse, they're on L1 visa, for example. So technically, they can even convert to L2 visa. So any proper work visa that their spouse has, they can convert to a dependent status on that visa. So one thing to note, however, is they can enter H1, but again, they are technically exempt from H1B cap lottery. So the day they find another employer, that employer can file an H1B, get an approval, and they can always convert back to H1B even down the line. So overall, yes, they can convert to a dependent status.
Yes. So, Mr. Parvathaneni, can one who loses job while on vacation in India look for a new H-1B job while still in India?
So the best case scenario is if somebody can get back into US while their final termination date happens, they should get back to US. But say they're not able to enter US because they've already been terminated, and also assuming they cannot even come back on H-4 visa because their spouse is not on H-1, say they don't have any other option. In that case, what they can do is they can still stay back in India and look for a new employer. So even if they're out of the country, they can still look for a new employer and still come back to US. The good thing is, because they have an H-1B, even if they lose their job, they're exempt from the lottery. So they don't have to go through the entire H-1B lottery. They just have to find a new employer who's willing to file the H-1B. And luckily, many employers nowadays, they're conducting Zoom interviews or online job interviews. So one can apply for a job, go through the online interview. If that employer accepts online interviews, many employers do accept online interviews. They can get a job from abroad, and they can again have that new employer file for a H-1B, and come back into the country with that H-1B. So that does happen a lot. So even if somebody unfortunately stuck in India and they lose their job, they can always find a new job while they're in India, and they can come back to US.
Yeah.
Two good things are they don't have to go for visa stamping again. Their old visa with the old employer's name, it's still valid. So they can still use that old visa. So that is a good thing. They don't have to waste their time on visa stamping. And another good thing is the 60-day rule does not apply to them. So what that means is they take 90 days to find a new job, 120 days to find a new job. They're still okay. The day they find a job, the day the new employer files and gets the H1, they can come back to US. So they don't have that time pressure that they have to find a new job within 60 days.
Okay. Mr. Parvathaneni, this is my personal doubt that just arose in my mind. So basically, my question is, let's say that, these people are on their H-1Bs and they have children and they are born here in USA. So, let's say they're on a vacation and they go there and the parent has lost their job. And the kid is still a citizen of USA. So in that way, is there any chance for them to come back to the country, or in that way, will the kids lose their citizenship also? So is that not a big mess that happens?
So again, a lot of Indians who are on H-1B who have kids born in US, the kids are automatically US citizens. However, the kids will not give the parents any right. So say the parents who are on H-1B, they are in a vacation, they are in India, and they lost the job. And the kids are enrolled in school in US. So US citizen kids, they're enrolled in school in US. However, the parents cannot use that fact and get any benefit to get a visa to come back to US. It's very unfortunate, but the way the rule works is until the children are 21 years old, they cannot really sponsor their parents. So technically, even if the child is a US citizen, the child is going to school in the United States. If the parents lose their job, the parents who are on H-1B, they lose their status. They cannot use their child's citizenship to come back to US. The only thing is once the child becomes 21 years old, because the child is a US citizen, at that point of time, the child can sponsor their parents. But until the child is 21 years old, it will not add any value from the perspective of letting the parents come to US.
Yeah. Okay. So, Mr. Parvathaneni, can we talk about how is green card process impact during the layoff season, especially?
Right. So, for the green card process, if say one is laid off and they're in the middle of their perm labor process, so the perm labor process, that is the very first step that a company starts for sponsoring somebody's green card. And during this process, say if somebody is laid off from their job, unfortunately, the entire application is gone and it will not give any benefit to the employee. So the employee loses that entire benefit, assuming they're in the middle of the perm before the I-140 is approved. So before the I-140 is approved, if they lose their job, absolutely they will have no benefit. However, if the layoff happens after the perm, after the I-140 approval, then they have some major benefits. So if the I-140 is approved for more than 180 days, then one can get full 3 years of H-1B time. They're exempt from the H-1B cap in the future. So what that means is, in the future, if somebody wants to extend their H-1B status, they can continuously extend their H-1B status based on the prior employer's I-140, even after the layoff. So that's an advantage if the layoff happens after the I-140 is approved. And another advantage is if the I-140 is approved and they lose their job after the I-140 approval, their date is locked. So everybody is put in a green card queue. So their position in that green card queue is locked. So they're not coming out of the queue and restarting the entire process again. So if somebody whose priority date is 2012 loses their job now, they are still in the queue for 2012 green cards. So they don't lose their position in the queue. So at least from that perspective, even after a layoff, their queue is not impacted. However, they still need to find a new employer and still need to restart the entire process once again.
Yes. So, Mr. Parvathaneni, is it true that one can only have H-1Bs for a maximum of 6 years? So, how do people stay after 6 years also?
So H-1Bs, every time a person gets a H-1B approval, it's for a max of 3 years each time. And the rule is currently one is allowed to get only a maximum of 6 years on a H-1B. Why 6 years? USCIS expects one to get a green card or be in the line for the green card if they need to extend their H-1B after 6 years. So within 6 years, if somebody is not a green card holder, or if somebody is not in the queue for a green card, they cannot extend their H-1B visa. So there are only two ways. Typically, one can extend their stay after 6 years. And the first one is to have the employer sponsor for their green card, finish both their perm process. Perm is the labor processing, and the I-140 process. So I-140 is the actual petition for their green card. So the employer has to finish the perm, has to get an approval for the I-140. If that happens, and the dates are not current, because typically what happens is all other countries except India and China, their dates are always current. So they get the green card very fast, very, very quickly. Unfortunately for India and China, the dates are backlogged, and this impacts India more than China. So anybody that's born in India, they typically don't get a green card very, very quickly in US. And for those people, if the dates are not current, but their employer has been able to do the I-140, then they can use that I-140 approval and continuously keep extending their H-1B even after 6 years. And they can keep doing this until they get their green card. So as long as their green card date is not current, they can keep on extending their H-1B because they have an I-140 approval. If they don't have their I-140 approval, if they did not find any employer sponsoring the green card, they have to leave the country after 6 years. So this is another reason why it is very important that somebody who's on H-1B, they find an employer who is ready to sponsor their green card. So if their employer is not ready to sponsor their green card, there is a problem after 6 years. Assuming they have an employer who's sponsoring their green card, they should be able to extend even after 6 years.
Yes. So, Mr. Parvathaneni, can you explain what is H-1B recapture of time? Is it something one can use to stay longer for more than 6 years in the US?
So recapture in general, it means to count the number of days that one is outside USA. For example, one started on H-1B in the country, but every time they go out of the country, every time they go out of USA, they can count those days and they can recapture all the time spent outside the country in vacations. So why is this important? Everybody has only 6 years on H-1B. After 6 years, if they don't have a green card process started, they don't have an I-140 approval copy, they have to leave the country. But with the recapture, what happens is every time they take a vacation, every time they're out of the country, we recapture all that time. So, for example, if somebody has taken, say, 6 months of vacation in the last 6 years, we can add that 6 months of time to their H-1B and recapture all that time. Why is this important? Because the sponsorship for the perm I-140 sometimes take a very long time. So if somebody is close to their 6 years period, the recapture helps them a lot. So an employer, they can apply for an extension after 6 years, and they can ask for that extra time they've been out of the country. They can ask that time to be recaptured. And even those few months, sometimes it is very valuable for somebody that has not received the I-140 approval. And by making sure everybody understands the concept of recapture, they can extend their time even after 6 years and wait until they get their I-140 approval. So this recapture is a very important concept. And right now, the dates, the processing time for perms and I-140s, it is very, very bad. And if somebody is on the borderline, this recapture is what would help them.
Yes. So, Mr. Parvathaneni, can you tell us some good practices that all non-citizens should do while in USA?
Sure. So there are some issues that any non-citizen in USA should consider. And when I say non-citizen, it's not only H-1B, it's not only F-1 students, but also green card holders. So there are some topics that anybody that doesn't hold a US passport, but living in US, they should consider. And typically, these are things like address changes. It's like somebody changes an address. What do you do? Job changes, a job change. Somebody changes a job. What do you do? International travel. What do you do during international travel? Key expiration dates, like for example, passport. What do you do when a passport expires, for example? And max out periods or age out periods. So a child can be a dependent only until they're 21 years old. So what do you do when your child who is crossing 21 years old, what do you do? So these are some of the things. And looking at each topic, for example, address change. What exactly should somebody do when somebody's address changes? So there is a rule, a very important rule that says anytime a non-citizen changes an address, they are supposed to notify USCIS. And the way they do it is through a form called AR11. And if AR11 is not filed on time, technically USCIS could even deport somebody. So not that they do it, but they technically can do it. What that means is it is highly important that anytime there is an address change, immediately within 10 days, they go to the USCIS website, they go to this form called AR11, they fill up that form. This is very important and there are no exceptions. So everybody should ensure they fill up that AR11 form. The next thing is job change. Many people have a visa status that is tied to their job. For example, H-1B visa holders. H-1B visa holders are approved only for that particular employer, only for that particular job, only for working from that particular location. Anything changes, there's a material change, there are requirements. The employer has to file an amendment, for example. The wage has to change. So anytime a H-1B employee changes work sites, they always have to ensure they are discussing with their employer, making sure their amendment is filed. They have to make sure they work full time like they're supposed to do. If it's a full time job, they're supposed to make sure they're getting paid as per the LCA. Anything is not compliant, they will have a problem down the line. So things like that are what they have to worry about regarding a job. Similarly, a student, an F1 student who is working on an OPT, they have similar requirements. How many days they can be out of a job, how many days they have to work, and so on. They have to make sure they absolutely follow those job change requirements. So doing so, they can ensure the job change. Anytime there's a job change, they're aware of the rules. International travel, it's very important. Everybody should understand that they have more protections when they are in US. Anytime they step out of US, they come back, the protections are not the same. The protections within US are a lot more stronger than what somebody has when they're trying to fly back into US and they've landed in US. At the airport, port of entry, the protections are a lot less than what they would have when they're inside US. So what that means is anytime somebody is leaving the country, make sure that you have a valid visa. Make sure you have a valid basis when you come back into the country. Make sure you're always compliant with the law. So it's very important. So people, it's very unfortunate, but a lot of times we hear that people travel out of the country and they're stuck for some reason. For reasons such as, hey, we're not able to get a visa back. We got a 221G, or we're not able to get a visa stamping date. So look at all those things whenever there's an international travel. And final thing is about the key expiration dates. At all times, somebody should have a valid passport. One cannot have an expired passport in US. What that means is, if your passport is expiring, you need to know when it expires. So that way, one can always apply for an extension. Same thing for an I-94. Any non-citizen that is in the United States, they have something called an I-94. At least majority of them. So always look at your I-94. Make sure you do not cross the date of your I-94. It is very, very important that everybody is aware of their I-94 expiration date. And same thing with the age out. Anytime you have a dependent child, if the child is about to hit 21 years old, there are some rules that one has to follow. So always make sure if your child is aging out and crossing 21 years old. So these are some good practices that everybody should be aware of. And doing so, they can ensure that they're always compliant with all the laws in the United States.
Yes. So, Mr. Parvathaneni, can you talk about some good practices companies that hire foreign nations in general should consider in 2023?
So a lot of companies that typically require highly qualified specialty occupation workers in the IT industry, there is a severe shortage of IT employees in the United States. And what that means is the companies are always competing for the talented labor pool. And in spite of all the talks we hear about layoffs, there is still a big shortage of IT employees. There is still a shortage of technical skills in the United States. So, from a company perspective, there are some things that even companies should take because the companies are actually fighting, they're competing for talent. So, if they don't, if they're not aware of things, they will not be able to compete for the talent. And if you look at the salaries that people make on H-1B, people make very, very good salaries, way above US median income. And the reason for that is because people who are on H-1B are talented and are highly sought out in US. So from a company perspective, H-1B lottery. Company should understand that there will definitely be a H-1B lottery again. So if a company is relying on new H-1B employees, they want to file for new H-1B employees, they need to understand that there is a good chance that many of their filings will not even get through the lottery. So a company should have a backup plan. So a company who just thinks that, hey, we have a job offer, we have an employee, it doesn't necessarily mean that tomorrow they'll be able to sponsor for them because they might not even be able to get through the lottery. So from a company perspective, definitely the company should have a contingency plan on how they will fill up their the open jobs. So they should not just rely on H-1B lottery process. Company should also explore L1s, and there is something called a L1 visa. So they should also look into that if they want highly skilled employees, or they should also look at H-1B transfers in case they're not able to locally find people. There is a local shortage. And another thing that the companies should keep in mind is H-1B is only for 6 years. If they want to keep an employee for more than 6 years, they have to sponsor for their green card. So it's very important companies look at their current green card sponsorship process. And if somebody requires a perm processing and I-140 processing, they start the process well ahead of time. This perm and I-140, this entire process could take almost up to a year and a half to 2 years sometimes. So companies have to really start their process well ahead of time, because otherwise what will happen is some senior employee in the company, they will realize that they cannot extend the H-1B and they will lose the employee. They don't start this process well ahead of time. So that's another very important thing for the companies. And another very, very critical thing is H-1B extensions. They have to make sure the extensions are filed on time. So doing so, they'll be able to ensure they're in compliance.
Yes. Thank you so much, Mr. Parvathaneni, for tuning on to our show. We covered a very important topic today. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.